Hello, welcome to today's segment of Our Ventura TV. My name is George Alger. Today we're going to be talking about the subject of bankruptcy. And our guest expert today is Doug Crowder, who is an attorney from Los Angeles. Welcome, Doug.
Hello, George. It's good to be here.
So that we're all on the same page, what is bankruptcy?
Bankruptcy essentially is a court proceeding that someone starts when they have more debt than they can pay. Sometimes it's done, most of the time it's done by the individual, either an individual or business who can't afford to pay their debts. Sometimes it can be done by a creditor who's trying to collect from the individual or the business, and that would be an involuntary bankruptcy, but those are rare.
Okay, so in terms of the differences between an individual and a business, are they distinct enough where we have to differentiate them for this conversation, or are many of the things you are about to say applicable to both?
Many of the things regarding bankruptcy apply equally to a corporation or an individual. There are some differences, and let me briefly just address the differences between an individual filing a bankruptcy and a business filing a bankruptcy. Most of the bankruptcies, the great majority of bankruptcies, are filed by individuals. And the reason an individual would want to file a bankruptcy, one would be because he or she just simply can't afford to pay his or her debts, and they may have lawsuits going on against them. Another reason they might want to file a bankruptcy is if their home is in foreclosure, and a bankruptcy can stop the foreclosure on their home, and sometimes allow them to keep their home. Now, a business filing a business can file a bankruptcy for basically a couple of different reasons. One is just simply to liquidate the business or close the business down. And another purpose of filing a bankruptcy would be to reorganize the business, such as is done in a Chapter 11 bankruptcy. And what a Chapter 11 bankruptcy will do is allow a business to continue operating while it comes up with a reorganization plan to pay off its creditors to some degree at least, and then it emerges, ideally anyway, it would emerge from the Chapter 11 bankruptcy and then continue business.
Okay. Now, if someone is in or under enough financial stress that the concept of bankruptcy enters their mind, is that a point where they should actually explore going through bankruptcy, or would you say there's a whole bunch of options you consider before that?
Well, anyone who comes to me to talk about bankruptcy, I always go over alternatives to bankruptcy with them and let them know what the different options are. I think it's always good to talk to an attorney early on, even before you're at the point where you're going to be filing bankruptcy. Most of the people who contact me, they've contacted me when there's some emergency situation going on, such as their house is about to be foreclosed on within the next week or two, or they have some lawsuits they have to take care of. But essentially some of the alternatives, let's say someone has way more debt than they can handle, they're behind on their credit card payments, they may have a lawsuit going on. Now, the first option is actually do nothing. And when I tell people the do nothing option, they ask, what does that mean, do nothing? And I just say, it means just do nothing. Just ignore the lawsuits. Just let them go ahead, file lawsuits against you, get judgments against you, let them try to collect. And that's a good alternative if someone is what they call judgment proof. Judgment proof is not really a technical legal term, it's sort of a slang term, but what it means is that if a creditor gets a judgment against you, they can't collect anything. Many people are in that situation where they're judgment proof.
Which just means they don't have enough assets.
They don't have enough assets, they don't really have any assets, or they don't have any income coming in. Because if a creditor gets a judgment against someone, the ways they can generally collect are, one, if the person is working for wages, they can garnish the wages and take up to 25% of their take-home pay. Or two, if they own real estate, they can put a lien on the real estate and either force a sale of the real estate or collect it when the person dies or transfers the real estate. But if someone's in a situation where they don't have wages, they don't have much as far as real estate goes, they don't have other assets, they might not be collectible. And a classic case of someone who's judgment proof is they don't have any real estate or assets to speak of, and their only income might be Social Security or disability payments, because those type of payments cannot be collected by a creditor. So that's the first option, just do nothing. And sometimes even if someone can get away with doing nothing and they don't have to worry about being collected from, they still might want to do a bankruptcy. So the bankruptcy I would call to be the second option. And for an individual, there's two general types of bankruptcy. There's a Chapter 7 bankruptcy, which basically just wipes out all the debts. And then there's a Chapter 13 bankruptcy, where they pay as much as they can afford to pay over a period of 3 to 5 years. And when I say as much as they can afford to pay, basically it's their income minus their expenses, and everything else goes to the bankruptcy trustee, who divides the money up amongst the creditors.
Okay, so this is a legal distinction then. So
Yes.
you're not sort of arbitrarily or personally deciding what your expenses are versus your income. Someone's looking at that and saying, oh, yeah, you definitely have to pay this, and obviously we see what your income is.
To some degree, yes, that's correct. But to a large degree, when someone's doing a Chapter 13 bankruptcy, they're more or less, to some degree anyway, able to decide how much they want to pay, how much they can pay.
Oh, okay.
And the way I operate it, the way I do it is I first, I do it in sort of reverse fashion. The proper fashion to do it in would be take their income, take their expenses, and see what's left over. But I do it the other way around. I ask them, how much do you think you could afford to pay? How much would you feel comfortable paying for the next 3 to 5 years?
I see.
And
Okay.
then based on that, then we look at their income and their expenses and see if the amount left over is more or less what they say they can pay. And if it turns out to be a big difference, then it may not work for them. But the reason someone would do a Chapter 13 bankruptcy versus a Chapter 7 bankruptcy, in some cases their income is too high, so they wouldn't be allowed to do a Chapter 7 bankruptcy. Or they may have assets that they don't want to lose in a Chapter 7 bankruptcy. But the biggest reason that people do a Chapter 13 bankruptcy is probably to keep a house from being foreclosed on. So that's the second option, which is the Chapter 13 bankruptcy. The third option is settling the debt. And in many cases, someone might be ahead just settling a debt versus doing a bankruptcy. Let's just say they only have just a few debts and the debts aren't very high. They might be able to just work out settlements with the creditors, where they either pay the creditors at a discount or get long-term payment plans.
And then when you're saying they, are you referring to the actual person under the duress, or would they hire someone else to do that for them?
Well, they could do it either way.
Okay.
Sometimes people can settle their own debts. They can do it easily enough. Sometimes they prefer just not to deal with it because it's difficult. Sometimes dealing with creditors, especially if they're your own creditors, it can be stressful and it can be difficult. And they would prefer just to hire someone else to negotiate their debts for them. As Abe Lincoln once supposedly said, a lawyer who handles his own case has a fool for a client.
Yes.
And the same way with someone who's trying to settle their own debts. Sometimes they have a fool for a client because they're too emotionally involved in the debts, and if someone calls them up saying, why haven't you paid, they may get pretty upset just because they haven't paid and they feel guilty about not paying. But if they call a law firm who's used to settling debts, the law firm doesn't care about it at all. And they know that they, meaning the creditors, know that the law firm can't be
They're not going to be manipulated.
Can't be manipulated, can't be forced to pay a debt that's not owed. And so that's one option. That would be option number 3, which would be settle the debt.
Okay. And number 4?
And number 4 is fight the debt. And here's an example where fighting it might be beneficial. If in the usual case, in the most common case where someone's filing a bankruptcy, they might have, let's say, 10 credit cards, and each of the credit cards is owed a certain amount, and there's not really any dispute about how much they're owed. So in that case, fighting is not really that good an alternative. But in some cases, someone wants to file a bankruptcy because they may have one lawsuit against them. And let's just say, for example, they're being sued by a former disgruntled employee who wants $500,000 from them. Now, what they have to look at is what their odds of beating the lawsuit would be, and if they can fight the lawsuit versus doing a bankruptcy and getting rid of the lawsuit with a bankruptcy. And so We just have to look at the fourth option, which is fighting the debt, to determine whether it would be in their better interest to fight the debt and possibly work out a settlement after putting up a good fight versus doing a bankruptcy.
Got it. I wonder if you could comment on the implications of a bankruptcy on a person or business's future.
On a business's future, a Chapter 7 bankruptcy will basically put the business out of business. If a corporation or any sort of business does a Chapter 7 bankruptcy, they're pretty much done with. They're going to be liquidated. If you go at Chapter 11 bankruptcy, some businesses successfully go through a Chapter 11 bankruptcy. A Chapter 11 is very complicated and very expensive, and from what I understand, the success rate is not very high. I don't remember what the percentages are, but I think it's less than 10% or less than 20% in any event of the businesses that do a Chapter 11 end up successfully emerging from the Chapter 11.
Wow.
But lots of times a business will go into a Chapter 11 just because they're intending to liquidate, they're intending to get out of business, but they'd rather do so under their own terms without all the creditors forcing them into a liquidation.
Okay.
Now, as far as the implications for an individual, a bankruptcy is a bad mark on someone's credit, and it stays on their credit for up to 10 years, for 10 years after they file the bankruptcy. Now, I don't actually do credit repair, so I can't really tell you how good or how bad a bankruptcy is going to be on your credit. But I know that in some cases, a bankruptcy can actually improve a person's credit score, because a person's credit score is based on their income to debt ratio. In other words, how much they make compared to what their debt is. And if they file a bankruptcy, then their debt is gone, and so they have a better ratio of income to debt.
That's interesting. It's somewhat counterintuitive on the surface, but I see how that works.
It is. And besides that, a future lender, if a potential lender is looking at someone, looking at their credit history and looking at their assets and their ability to repay, and they see that this person has, for example, quite a number of unpaid credit cards, or they see the person has several unpaid judgments, they'll know that person isn't a good credit risk.
Got it.
But on the other hand, if they had some unpaid credit cards and some unpaid judgments, but they just filed a bankruptcy to discharge or get rid of those credit cards or judgments, then they'll know that that person has more money with which to pay that creditor, so they could be a better credit risk.
Thank you, Doug. There's more I'd like to ask you, but we're just about out of time. I'm wondering if you could provide a website that viewers could go to for more information, and is there a summating message you'd like to convey to the viewers?
Sure, George. The website that they can go to is crowderlaw.com, which is spelled same as my name, crowderlaw.com. The summating message is basically just have a quick look at the four alternatives. Whenever you have too much debt, it's a good idea to talk to an attorney, and whoever you talk to should be able to tell you what your alternatives are. One is to do nothing, just simply ignore the debt. Let them, if you're judgment proof, that's a good alternative. A second alternative is a bankruptcy, either a Chapter 7 or a Chapter 13, depending on your circumstance. The third alternative is to settle the debt, and the fourth alternative would be to fight it.
Thank you, Doug.
Thank you, George.
This is George Alger signing off for this segment of Our Ventura TV. Until we meet again.